Bryan Kohberger appears in court. The affidavit for probable cause is released. Lori Vallow says, "I'm not crazy and you can't kill me." An update on the plunging Tesla driving doctor. What have I said about dating apps? Dangerous. Another reason to avoid them. And then finally, our dumb criminal of the day. And you can put this one in your "you can't make this stuff up" category. Let's talk about it. Good day, everyone. My name is Scott Reich, and this is Crime Talk. Thanks for watching. You know the drill. Subscribe if you haven't. Like if you do. Leave me a comment below. Hit that little bell so that you receive notifications when we go live or put up new content. And remember, you can listen to us on any of your favorite podcasting apps just by simply searching Crime Talk. All right, let's go ahead and open the record for the docket for January 5th, 2022. Well, Bryan Kohberger was denied bail today, not surprisingly, during a very brief, short court appearance that we brought you earlier today. And also the affidavit detailing the prosecutor's case was also shared. Now, Mr. Kohberger spent most of the 10-minute hearing looking directly at Judge Megan Marshall as she read him the charges and the possible penalties and advised him of his rights as it relates to the 5 counts where he responded yes, that he understood each of the charges against them. He will return to court on January 12th for a status hearing. Now, I read to you verbatim the affidavit for the arrest warrant earlier, and frankly, I think we did it pretty flawlessly. A couple of times I had to start over, I'm not going to lie. But the point is, we read it word for word. We can summarize it, but I really think it has to be read in its entirety to get the whole context of the investigation. But what we do know is that Kohberger's DNA was found on a button on the knife sheath and it was close to the bodies of Maddie Mogen and Kaylee Gonsalves. Now, the affidavit also details how a surviving roommate, Dylan Mortensen, came face to face with the perpetrator, who she described as a masked man, who everyone believes to be Kohberger, in the hallway of their shared home around the time of the killings, shortly after 4 a.m. on November 13th. It states in the affidavit that Mortensen heard what she believed to be her roommate's cries. She left her room and saw a man in a black mask with bushy eyebrows and 5'10", maybe taller, and she froze with fear and watched as he walked past. Then she waited 6 hours before calling the police. Now, there's additional details that Kohberger allegedly stalked the victims was shared. His phone was found to have been near the residence there in Moscow on at least 12 different occasions, starting back in mid-August. Now, the phone was apparently turned off at the time of the alleged killings, but there's video evidence basically detailing the travels, as the police allege them to have taken place, from video cameras both at the Washington State University as well as traffic cameras throughout the city and on the highways. Very interesting. And just as the police suspected, although the phone was off that night, it doesn't mean that he wasn't, for lack of a better term, stalking or casing the joint beforehand. So unless Mr. Kohberger has a legitimate excuse as to why he was there, like maybe he was tutoring up the street, he's got some explaining to do. Obviously, the DNA is going to be the biggest problem for sure, but as I said, go listen to the video. We will put a link in the video so that you can have the entire affidavit for your own edification. Now, if convicted, Mr. Kohberger faces the death penalty for the murders there in Idaho of Maddie Mogen, Kaylee Gonsalves, Zena Kernodle, and Ethan Chapin. And like I said, probably the toughest evidence he's going to have to overcome is the DNA sample taken from the button on the knife sheath, and then they match that with some DNA from trash in Mr. Kohberger's family residence there in Pennsylvania, which they were able to test in one day. and they were able to make that match. Now, the sheath is described as a tan leather United States Marine Corps K-Bar insignia stitched on the exterior. Can you imagine when he allegedly realized he left that behind? Oops. Yep. Anyway, go check out the link. Listen to the entire affidavit. Next on the docket, Lori Vallow. I'm not crazy and you can't kill me. That's right. So a couple things needed to take place. Some motions were due in the Lori Vallow case, specifically as it relates to a mental health defense. And that has to be done prior to trial to put the prosecution on notice. And the defense did put the prosecution on notice. And basically it says that the defendant has hired and consulted with at least 3 independent health care experts to review and evaluate Lori Vallow's mental health. And due to ongoing mental health concerns while this case has been pending, the court even conducted an evidentiary hearing on November 10th of 2022 to determine if she was competent to stand trial. And on November 15th, the court ruled that she was competent to stand trial. Her attorneys still state, although still suffering from a mental illness, the defendant is taking an active role in her defense. She has previously reviewed all of the discovery provided to her by the state and her attorneys. She has consulted with 3 mental health experts. She does not want to proceed with a mental health defense to negate an element of a crime in this case. She has not authorized her attorneys to proceed with a mental health defense in the guilt phase portion of this trial. Her attorneys are respecting her autonomy and her rights granted to her by the Constitution of the United States. If she is found innocent of the charges, then no such disclosure of expert witnesses will be necessary. If, however, she's convicted by a jury, then the defense will call witnesses, including experts, in support of mitigation during the sentencing hearing. So Lori Vallow doesn't want anybody to think that she has a mental disease or defect that would actually negate one of the elements of the crime, obviously of first-degree murder. If you didn't knowingly do something, you can't be convicted of it. Very, very interesting indeed. Now, that is a CYA for the attorneys. So if there's a conviction and there's a post-conviction challenge to any conviction, this takes away, why didn't you run a mental health defense? It's so obvious. She wouldn't let us do it. So they're respecting her wishes, and more than likely at the sentencing phase, they will put on mental health evidence, hopefully, or their intent is to hopefully then save her life. The next document filed by the defense on behalf of Lori Vallow is that, hey, you can't put Lori Vallow to death. It's a violation of the 8th and 14th Amendment, the cruel and unusual punishment, which falls through to the states via the 14th Amendment, and said, yeah, she's been charged with first-degree murder and conspiracy to commit first-degree murder and grand theft and they all carry the possibility of the death penalty. Now, as charged, the defendant does not have the requisite culpability to be charged with a death penalty under the indictment for conspiracy to commit first-degree murder and grand theft, nor a principal or an accessory to first-degree murder. And her counsel then go through a couple of examples. One is a case out of Florida. It's called Edmond v. Florida, and it was decided by the Supreme Court in 1982. And Mr. Edmond was charged with murder of Thomas and Eunice Kersey. And Edmond was a getaway driver for an armed robbery gone wrong. And when Edmond's 2 accomplices went to rob the Kerseys at gunpoint, one of the victims grabbed a gun and shot at Edmond's accomplice, injuring her. The accomplice shot back and subsequently killed both Thomas and Eunice Kersey. Edmond was convicted of first-degree murder and sentenced to death. The Supreme Court granted certiorari to hear the case. And under the proposition that Edmond v. Florida stands for, is a person who neither kills nor intends to kill and has not the requisite intention of participating in or facilitating a murder cannot be put to death. The court explains that for purposes of imposing the death penalty, Edmond's criminal culpability must be limited to his participation in the robbery, and his punishment must be tailored to his personal responsibility and moral guilt. Now, that case revolved around a felony murder conviction where somebody dies in the commission of a specific offense, usually arson, aggravated robberies, and burglaries, something along those lines. And basically saying, hey, this really shouldn't fit the bill. Now, I get it. Lori Vallow has some very, very good attorneys. Mr. Archibald, very competent. His co-counsel in this case, Mr. John Thomas, obviously doing very good work, very qualified death penalty attorneys. They're making these records for the appellate record. Let's face it, I don't see Judge Boyce stepping out on a limb and creating new death penalty law for the state of Idaho. Simply do not see it. And so this is stuff that, law review articles are written about that no one ever reads, unless, of course, you're doing death penalty law. So it's very well written. It makes complete legal and logical sense. But I think the court would say, well, let's see what the jury does, and then we'll decide if the death penalty really applies at that point. That's what I anticipate taking place. Good lawyering. Don't get me wrong. Very, very good lawyering. But I don't think she's going to get any relief. But it's also very interesting that she doesn't want anybody to know she's got mental health issues, even if it could possibly set her free, or at least send her back to the state hospital versus prison. Very, very interesting indeed. Next on the docket, an update on the plunging Tesla doctor. Remember yesterday we brought you the story of the doctor that drove his Tesla off a cliff some 250 feet in an effort to kill himself and his family, which includes a wife and 2 children. And he failed miserably at it because apparently the Tesla is so well built that that's right. Everyone survived with little to no injuries. The doctor himself actually suffered the worst injuries, and he's still in the hospital. Well, guess what? Apparently, just prior to that, everything was easy peasy, normal as you could possibly imagine. They've got Ring video that shows Dr. Patel dropping off a poinsettia plant at his neighbor's home on Christmas Eve before he then left to Northern California for the holidays, where he then allegedly drove his Tesla off the cliff for the purpose of killing himself and his family. That's right. I mean, I just don't get it. Hey, I'm going to take the family and do away with them, but first we need to drop off this poinsettia. We don't want to disappoint anybody. Are you serious? So Dr. Dharmesh Patel, he still remains in the hospital, as the neighbors around him said that he and the family were the ideal family. And they had no idea that the family was struggling in any way whatsoever. So the good doctor, being Mr. Perfect to everybody else out there in the world, which just shows you, ladies and gentlemen, all those people on Facebook, Instagram, to make it look like the perfect world, not always perfect. They maybe want it to look perfect. Just remember, it's not always what people purport it to be. Anyway, once released from the hospital, Dr. Patel will be booked on charges of attempted murder and child abuse. He is accused of intentionally and inexplicably driving his electric car 250 feet off the notorious section of the Pacific Coast Highway known as Devil's Slide, known at about 10:50 a.m. on Monday. I just don't get that. And I just couldn't imagine a car being plunged off the top of that 250 feet and you survive. I mean, like I said, I wasn't a big fan of electric cars, but maybe I need to get one of those. Talk about safety. Jeez, that should be the new safety test. If I want to harm myself and my family and I plunge it off the 250-foot incline cliff, would I survive? I don't know. All right, next on the docket, dating apps. That's right. I've told you the dangers of them. Be careful out there, ladies and gentlemen, which is a good segue into one of our sponsors. That's right. Hit that link to crimetalksearch.com. Why? Well, after this story, you're going to realize, yes, Scott is correct. You need to check people out. You meet people. You don't know much about them. It's not like they're going to tell you all of their woes and their life stories and, maybe some weird proclivities that they have, like maybe wanting to kidnap women, things like that. You want to find out. You want to dig as deep as you can because usually there's something there that says something's not right. So go to crimetalksearch.com, get that background subscription service today. Remember, you can cancel anytime, but when you have that subscription, you can perform as many background searches as you would like. And you get a report literally as you wait, and it's going to have information regarding one's criminal history, property records, divorce records. You know, if somebody's on a dating app, you maybe want to check it out and see if, I don't know, they're single, little things like that. Go to crimetalksearch.com. You'll be happy you did. So a 21-year-old Texas man has been charged with kidnapping a woman that he met on a dating app and then torturing her for 5 days. I mean, who says that's not normal, right? So the Harris County deputies allege that Zachary Mills was arrested on December 30th, a day after the 22-year-old woman escaped and ran to a neighbor's for help. The victim was taken to a local hospital for treatment of serious injuries. The police stated the victim in this case has severe injuries to her face, orbital sockets, lower extremities, and thankfully, though, we were able to take her to the hospital very quickly. Now, Mr. Mills and the woman apparently exchanged messages on the app Bumble. They agreed to meet. Mills picked the woman up and drove her to his apartment, where he held her against her will, refusing to give her food, and then repeatedly, allegedly sexually assaulting her and then beating her. From that point forward, he did not leave her alone. He then withheld food and water. Now, investigators, police have charged Mr. Mills with aggravated kidnapping and say that more charges will more than likely be filed. Now, Mr. Mills' attorney absolutely dismissed this, saying he has not seen anything in the allegations that make these allegations credible, like the injuries. I mean, come on. Orbital sockets, broken orbital. She probably did that herself. It was all completely consensual. She was practically begging to beat up. That's what the attorney's saying. We'll give him the presumption of innocence. Well, Mr. Mills posted $50,000 bail and now must remain under house arrest. His next court date is in February. All right, then finally today, our dumb criminal of the day. A Florida man and his girlfriend wound up in jail after allegedly dialing 911 for help committing a crime that was actually in progress. Martin Gonzalez Garcia and Ashlena's Roldan Oscario placed a 911 call to deputies asking for assistance moving items out of a home they were in the process of burglarizing and asked them to give them a ride to the airport, according to a press release from the Polk County Sheriff's Office. Now, the call in question, authorities say, was placed by the girlfriend. She said she called 911 for the purpose of having law enforcement assist her and Mr. Martin with moving their belongings from the house, the one that they were burglarizing. And they were trying to get a ride to the airport because they wanted to go to New York for the weekend. I mean, who doesn't? Why not call the police? They're like Uber, right? Well, needless to say, the deputies responded somewhat tongue-in-cheek in their post and said, yes, the deputies did help them with their belongings and did give them a ride, but it wasn't to the airport. It was to the Pokey, according to the cheeky response. Authorities claim the sequence of events began at approximately 1 p.m. on December 29th of 2022. Apparently, at that point, a Dollar General store located in Kissimmee, Florida, was burglarized by the adult male who allegedly made off with multiple stolen items. Deputies responded to the burglary call at the store and obtained video camera surveillance footage. While reviewing the security video, one of the deputies on the scene allegedly recognized the suspected burglar as Gonzalez Garcia, apparently known to law enforcement. Lucky guy. Deputies searched for Mr. Gonzalez Garcia, but they were unsuccessful. Later that day, deputies responded to a seemingly unrelated call at a residence after an individual allegedly called 911 but did not speak. When the deputies arrived at the home, they realized that no one resided at the residence. When they entered the premises through an unsecured door, and they went inside to make sure everything was all right. That is when one of the deputies recognized that Mr. Gonzalez Garcia, the subject of the active warrant for the Dollar General burglary, was inside the home with a woman, later identified as his girlfriend. According to the affidavit for arrest warrant, Mr. Gonzalez Garcia and Roldan Oscario both admitted that they did not own the home and had entered through the sliding back door. And Gonzalez Garcia and Roldan Oscario were both charged with burglarizing the unoccupied home, which they were arrested. Gonzalez Garcia also sat down in a recorded conversation with investigators and just happened to confess to burglarizing the Dollar General store as well. He said that he knew what he did was wrong, but he needed the money, and he would have pawned the items and used the cash. The couples were also charged with possession of cannabis and drug paraphernalia. Both of the defendants are scheduled to appear in court for an arraignment later in January. All right, so we had a big day today. We went live with the affidavit for probable cause to arrest Bryan Kohberger. We had his very brief court appearance where he was advised of his rights, the charges, and possible penalties. And then today we brought you a daily video. Yes, we've been busy. I hope you've enjoyed it all. Have a wonderful day, not just a great day, but a wonderful day. And we'll see you next time on Crime Talk.